Judge Kenneth D. Bell warned back in June that the 2311 Racing and Front Row Motorsports lawsuit against NASCAR could burn this house down, and now, with trial set to begin in less than a week, tensions are reaching a boiling point. The antitrust case, filed in October 2024, alleges that NASCAR engaged in anti-competitive practices to maintain a monopoly over premier stock car racing. 2311, co-owned by Michael Jordan, Denny Hamlin, and Curtis Polk, alongside Front Row Motorsports, claims that NASCAR's charter system, non-compete clauses, and control over car components suppress revenue and limit competition, violating the Sherman Antitrust Act. The dispute traces back to prolonged negotiations over charter agreements for 2025 to 2031. While 13 of the 15 teams agreed to terms that increased payouts by over 60%, and allocated $50 million in additional revenue, 2311 and Front Row refused to sign. They allege NASCAR manipulated charters, acquired ARCA Racing, and merged with track-owning entities to solidify control, while enforcing exclusivity clauses and single-source car components. These actions, the teams argue, restricted their business opportunities and market value. NASCAR counters that 2311 and Front Row are merely pursuing negotiation through litigation. Lead attorney Christopher Yates argues that payouts have increased, enterprise value of charters has skyrocketed, and exclusivity clauses are standard practice in sports. He notes both teams have previously agreed to charter terms without raising legal concerns, and that the single-source car platform reduces costs and ensures competitive balance. Mediation efforts over the summer and in October produced no resolution, with disputes over legal fees derailing progress. The trial will last 10 days, with 6 jurors tasked with reaching a unanimous decision. Both sides have filed hundreds of exhibits, and witnesses are expected to include team owners, executives, and field experts. 2311 and Front Row are seeking over $300 million in damages, plus antitrust remedies that could reshape the charter system, including eliminating non-compete clauses and single-source provisions. A victory for the teams could still leave them without their charters, while a NASCAR win could see 2311 and Front Row exit the Cup Series by 2026. Any verdict is likely to be appealed to the Fourth Circuit and potentially the U.S. Supreme Court. Judge Bell has indicated openness to reviewing the legality of the charter system itself, heightening the stakes for all parties involved. As the trial approaches, both sides face immense pressure to settle, yet the potential ramifications for the sport are enormous. Whether NASCAR maintains control, or 2311 and Front Row prevail, the outcome could fundamentally redefine how the Cup Series operates and how teams compete in North America's premier stock car racing championship.